Good afternoon, everyone, and welcome. I'm Catherine Coulter, and I lead our employment group here in the Dentons Ottawa office. I'm joined today by my excellent colleague, Matt Curtis, a partner in our Dentons Toronto employment group. And some of you may know that on August 6th and 7th of this year, it was a little bit like a gift opening day, as you will, for employment lawyers, especially here in Ontario. Those are the days that the Ontario Court of Appeal released their decisions in the extremely important cases of Baker and Van Dolder's home team, as well as Wigdor and Meta. The Baker case had to do with the enforceability of termination provisions, and the Meta case had to do with the treatment of equity upon the termination of employment. Our office blogged pretty extensively about both cases, in each case on the day of the release, and you can read more about them in our Dentons Employment and Labor blog. But today we're going to have some fun unpacking the cases a little bit more and giving you some things to consider for your businesses going forward. We're going to dive right in, and we're going to start with the Baker and Van Dolder decision. So, Matt, over to you.
Yeah.
Can you give us a quick summary of what the case was about and what the Court of Appeal decided?
Well, thank you, Catherine. And yes, an exciting time to be an employment lawyer in Ontario and across Canada. These two cases, the Baker and Lee decisions, were ones dealing with termination clauses in employment contracts, and there were two conflicting lower court decisions with respect to language in the termination clauses in those two respective cases. In the Baker case, it allowed for termination of employment in a without cause termination at any time, as well as a just cause termination provision, which had an extensive list of examples of what could constitute a just cause for termination. In the Lee decision, there was again that termination language that allowed for termination without cause at any time and for any reason. And the lower court found in the Baker decision that the clauses were unenforceable, resulting in common law reasonable notice being awarded to the employee. Whereas in the Lee decision, the lower court decided that the language was fully enforceable. The Ontario Court of Decision heard these two cases and rendered a decision at the same time in both of them. And they allowed the employer's appeal in Baker and dismissed the employee's appeal in Lee, and found that the just cause and the without cause termination provisions were enforceable. And the rationale of the Court of Appeal at a high level was that it showed an objective intention in both employment agreements to comply with the minimum Ontario Employment Standards Act requirements upon termination of employment. And the court said that even though the words at any time could potentially undercut the Employment Standards Act on a very literal, very legalistic approach viewed in isolation, that approach would miss entirely the fact that the intent of the parties was to comply with the Ontario Employment Standards Act. And that intention was further supported by fail-safe, what are called saving provisions, which referenced the Employment Standards Act, and that the intention of the party was to comply with the Ontario Employment Standards Act and minimum employment standards. So ultimately, the Court of Appeal decided there was no inconsistency with respect to the contractual right to terminate without cause at any time or for any reason, and that in reality, in those two employment agreements, there was an intent to always abide by the minimum employment standards.
Thanks. That's a lot. Why is this all important from a legal point of view? What does it mean?
Well, at a very high level, it shows a big shift in the approach and of the courts in Ontario and likely across Canada if other provincial superior courts apply the approach made by the Ontario Court of Appeal. The shift is no longer looking at words in isolation from one another, and instead, we're now looking at the objective intention of the parties when they enter into these employment agreements, and to see and to use a common sense approach and to review the contract as a whole rather than in individual sort of morsel-sized pieces. There's a number of lower court decisions in Ontario and across Canada where there's been a very legalistic approach taken with respect to employment termination clauses, whereas now with this new decision of the Court of Appeal in Ontario, we're now going to be looking at what's the intent of the parties when they entered into the employment contract. And it's going to be a broader approach in terms of reviewing what the actual termination clauses say. The Court of Appeal also has told the lower courts that not to find ambiguity where none exists, and that these hypothetical situations that could occur should really be looked at more holistically as to what does the language say in the entire employment contract and not individual pieces of the contract.
Just out of curiosity, what if there is ambiguity, or what if there is a significant drafting issue with the provision?
If there's a clear ambiguity, it will still be decided by the court in the employee's favor. So it's got if there and if there is a clear ambiguity, then that's one where the employee will succeed in having that termination clause non-enforceable. But the days of looking at hypothetical situations, I think, are behind us based on this shift in the interpretation that the Court of Appeal has told employment lawyers and practitioners to use when it comes to interpreting employment contracts and those termination provisions in particular.
Okay. What's this going to mean for our clients and for people who are attending this call? What's this going to mean in general for employers, I would say both in Ontario and potentially across the country?
Well, I think it involves looking at those employment agreements and those offer letters to use this as a good opportunity to review the language, because the Court of Appeal certainly didn't say that it's open season, that all termination clauses will be enforceable in Ontario based on this court decision. That's certainly not the takeaway here. So as a step, I would argue is that it's a good time to look at those offer letters of employment or your employment agreement templates to make sure that the language complies with the Ontario Employment Standards Act, and that there's the fail-safe language, savings provisions within the contract, and also just to ensure that there's a very clear, explicit intention in all parts of the termination clauses, both without cause and just cause, to show an intent to comply with the minimum employment standards. That was very, very important in both cases that were before the Court of Appeal, and the court scrutinized the language very carefully in the whole contract with respect to having an objective intent to show that the parties at the time of entering into these agreements meant to be bound at all times by the employment standards. The other takeaway is to put in savings language. That sort of became a bit out of favor in the past few years, but I would recommend now reinserting them if you've ever taken them out, because I think it's important as part of that intention to show compliance with the minimum employment standards. And then the other takeaway is that this is definitely shows a shift more, I would say, of a balanced approach with respect to how to interpret an employment contract and how the courts will look at it. But it does still show that it's very important that careful drafting be done when it comes to an employment contract or an offer letter.
Thanks, Matt. Do you have anything else to add, or should we dive into the Wigdor and Meta case?
Just two more points I would say as key takeaways. There is still this case, Wakesdale, that has been very troubling to employers in Ontario, where that case that went to the Court of Appeal found that if that all termination clauses need to be read together, so a defective just cause termination provision could lead to the entire termination provision and not being enforceable. That is still good law for now. The Court of Appeal in the Baker decision did not overturn that, but they also didn't review it either. For now, that Wakesdale case is still the law in Ontario, so something to be careful about. And then the other point is that termination clauses that reference explicitly the Employment Standards Act are now more likely than they were last month to be enforceable in Ontario if carefully scrutinized and carefully drafted. And it can also be a factor in your severance negotiations. There's been a bit of a shift in the pendulum with employee counsel in Ontario after this Court of Appeal decision, and I think that can be very helpful in respect of severance negotiations post termination, and the ability now to rely upon this Ontario Court of Appeal decision, which is very important and very recent, to manage expectations of severance entitlements by employees.
On that last point, do you think that might open the door then to potentially more claims in relation to things like bad faith termination, discrimination, and the like, as an attempt to get a foothold into a larger package where none actually exists with the
It
termination?
does seem, Catherine, that it is a bit of whack-a-mole in these cases, and I do expect and have already seen more and more discrimination claims and bad faith termination claims with respect to the manner of termination and things of that nature. So perhaps a move away from how the contract of employment is drafted to more of these ancillary issues that employee side counsel might be relying upon a bit more in the future, given this very important Ontario Court of Appeal case that was decided in the case of the employer. Okay. So with that, I think we'll move on to a second very important Ontario Court of Appeal case decided or issued the day after the Baker and Lee decision, and that's the Wigdor and Meta platforms case. And Catherine, I know you've been looking at this case very, very carefully, and so perhaps you could give us a high-level summary of that decision and what the Court of Appeal decided.
Sure, I'm happy to do that. And for anybody that's on the call that thinks, well, we don't have an equity plan, I don't need to stick around for the rest of the call, I would encourage you to stick around, because the principles that hold true according to the Court of Appeal with Wigdor also hold true with respect to things like bonuses and commissions post termination. And so it's a good case from a number of different standpoints. So let me just tell you a little bit about the facts of the case. Dr. Wigdor became an employee of Meta when his company was acquired by Meta. And as part of his compensation, and that's really important, and I'm going to come back to the compensation piece, he received a grant of what are called restricted stock units, or RSUs. They're a form of equity that one generally hopes are going to increase in value over time. When his employment was terminated, the documents that governed his RSUs stated that his vesting rights came to an end as of the date of notice of termination. And that's important. And the issue is that the Ontario Employment Standards Act, or the ESA as I'm going to refer to it, states that all terms and conditions of employment must continue through to the end of the statutory notice period. The RSU documents governing Dr. Wigdor's entitlements simply didn't permit for that, and therefore they undercut his statutory entitlements, which is an absolute no-no. On a separate note, and also important, the lower court had decided, and the Court of Appeal actually affirmed, that due to an issue with Dr. Wigdor's probationary clause in his employment agreement, he was entitled to common law notice comprised of all compensation. And the question in front of the Court of Appeal then became whether that included the continued vesting of his RSUs during that longer common law notice period. The Court of Appeal ultimately decided that the lower court hadn't interpreted the ESA correctly. It's a technical argument. It involves sections 60 and 61 of the ESA. I'm not going to get into them in detail, but the court effectively said two things that were really important. First, that if you take sections 60 and 61 together, they're intended to place the employee in the same financial position, whether they're provided with working notice or pay in lieu of notice. So however you terminate them, you need to keep everything the same. And secondly, the word amount in section 61(1)(a) isn't restricted to wages, quote unquote wages, but instead includes all forms of compensation to which the employee was entitled during the statutory notice period. That discussion about wages, that's the important part for people who don't have equity plans, because bonuses, incentive bonuses, or as we call them, non-discretionary bonuses, and commissions both fall under the definition of wages, not just in Ontario, but other provinces as well. And so using this analysis to get around what the lower court had decided, it opened up the door for Dr. Wigdor to receive approximately US $5 million in extra money for the RSUs that should have continued vesting until the end of his very lengthy common law notice period.
Okay. That's great, Catherine. Now, does that decision, which was decided in favor of the employee, does that conflict with what I was just talking about, the Baker decision, which was decided in favor of the employer?
It doesn't. They're two different cases. They have two different legal issues at play. I think they're easily reconcilable. I think the more important question is, why is the Wigdor case important? And I think that the effect of Wigdor is twofold. So let's step back for just a second. The appeal court effectively said that because Dr. Wigdor's RSUs were part of his compensation, his rights under the RSU plan had to continue to the end of his statutory notice period because, as I said, in turn, the ESA mandates that all terms and conditions of employment must continue through to the end of that statutory notice period. Looking forward at other cases, this presents the following two issues for employers. So first, if you have a situation like that in Wigdor, the undercutting of the ESA in a separate equity document, it can undercut the entire termination provision in the employee's employment agreement. And I'll come back to that. In turn, this means that the employee is entitled to greater common law notice instead of just their contractual entitlements. So, interesting point. The court awarded Dr. Wigdor common law notice based on an improperly drafted probationary clause. The issue of the undercutting of the ESA due to his equity entitlements was never in front of the court that I can see, but I think they could have equally jumped to common law notice based on the fact that the equity documents undercut the ESA. Secondly, if the employee is going to be entitled to that greater common law notice, that's going to extend not just to the pay in lieu of notice portion of the package, but it also means that the employee, just like Dr. Wigdor, is going to be able to continue with vesting their equity or increasing the value of their equity by way of damages until the end of that greater common law notice period.
Okay, and now, Catherine, is this decision just limited to RSU plans, or does it have like a wider implications?
Yeah, that's a great question. Look, this was an RSU case, and our courts generally just deal with the facts before them. They don't tend, other than the Supreme Court of Canada sometimes, they don't tend to go off on tangents and give their opinions in relation to things that are not in front of them factually. So while this means that your question is technically unknown at this point in time, I think we can pretty safely assume that the Wigdor decision applies to other forms of equity, such as the vesting and exercise of stock options, provided that they're granted as part of an employee's compensation. So in this case, there were actually documents and tax withholdings, which made it very clear that everyone at Meta, Dr. Wigdor himself, and the courts saw Dr. Wigdor's RSUs as being part of his employment compensation. And the Court of Appeal actually went out of its way to itemize the ways in which Meta treated those RSUs as compensation. But, and this is a roundabout way of answering your question, there's actually a 2021 case from the Ontario Court of Appeal again. The case was called Mickelstein's. And in that case, Mr. Mickelstein was entitled, but not required, to purchase shares in the company, as were all other employees. He wasn't required to do so, though, as I say. He was subject to a shareholder agreement, and that shareholder agreement cut off his share rights as of the date of notice of termination instead of the end of the statutory notice period. So, very same court ruling on it as ruled on the Wigdor case. And in fact, in the Wigdor decision, the Court of Appeal referenced Mickelstein's and said that the wording of the plan in Mickelstein's was fine and it didn't undercut the ESA, even though it was a shareholder agreement, because the shares weren't part of his compensation. They weren't part of any employee's compensation. They weren't mandatory, and they were purchased with the employee's own money. So I'm going to play devil's advocate for a second here. I have a little bit of trouble squaring the circle with the court's analysis in Mickelstein's. And I think that the court was just struggling to try to figure out how to put all of this together, their prior decision and their current decision. If Mr. Mickelstein's hadn't been employed by this particular employer, then he wouldn't have been given an opportunity to purchase shares in the company. It was a private company. Although he had to pay out of his own pocket for the right to purchase those shares, and although the shares weren't part of his compensation, I think it's at least arguable that the option to buy shares was a term of employment. And if it was a term of employment, then it should have continued. But I'm not a court of appeal judge, and so there you go.
Maybe we'll take another Court of Appeal decision to decide that one, Catherine.
Well, I'm also just going to quickly note here that the Court of Appeal in Wigdor mentioned in passing that it should be left to another court to determine whether or not all forms of equity compensation fall under the statutory definition of wages. That issue is purposely not touched by the court, and it remains a live issue. And it is possible that we could see a motion for leave to appeal to the Supreme Court of Canada on that point.
Well, Catherine, what are some of the key takeaways from this decision for employers?
Sure. I've got 3 takeaways for you, Matt, and for your audience as well. So number 1, the key principle, and I've already mentioned it, is that equity which forms part of an employee's compensation must be continued through to the end of the ESA notice period in Ontario, both in practice, but also in terms of the equity plan or the equity agreement language. Okay, it's not good enough just to continue it if you don't have the right language in the plan and or agreement. And if you have the right language in the plan and or the agreement, but you don't continue the vesting, you're going to be in trouble as well. So the courts in other provinces often look to Ontario case law, but they're not bound by it. And while they'll sometimes follow it, I would say they'll often follow it. It's not always the case. So there are other provinces which have similar language around continuing all terms and conditions of employment during the statutory notice period, but not all provinces do. For those that do, I think that they're going to end up mirroring the Wigdor provision. And I'll tell you this, the Alberta court last year, in the case of Lischuk and KJ Electric, effectively came to the same decision as Wigdor in relation to bonuses based on shareholdings. It's a little bit different how they got there. They relied on a Supreme Court of Canada case from 2020 called Matthews and Ocean, but it took them to exactly the same place. An employee who was entitled to common law notice and who was entitled to bonuses based on his shareholdings was therefore entitled to those bonuses right through to the end of the common law notice period. But it is possible that some other provinces may take a different approach. Here's the second key takeaway. Keep in mind that even if you fix the issue in the Wigdor decision, if you have a termination provision in your equity plan or your equity agreement that undercuts the ESA, and I'll give you an example, an overly broad termination for cause provision, your company is going to remain exposed to a court striking down an otherwise valid termination provision in your separate employment agreements. And I'm going to take everybody back to 2020 and 2021 in the case that you mentioned, Matt, the Wachsdale or Wakesdale case. That case, I assume everybody is aware of it, but it stated that any part of a termination provision which undercuts employment standards entitlements is going to invalidate the entire termination provision. In turn, that Wakesdale case has been followed by other cases in Ontario which have taken the principle a step further. And they have stated that an invalid termination for cause provision in any document which applies to the employee is going to invalidate an otherwise valid termination provision in the employment agreement. So, by way of example, if you have a US-style equity plan with a very detailed termination for cause provision, and I see them all the time, you're going to run the risk of your terminated Canadian employees being entitled to common law notice because that termination provision in an entirely separate plan document invalidated the termination provision in the employment agreements. So even though equity vesting may have ended with the conclusion of the ESA notice period because you got that part of the equity plan right, those employees may be entitled to common law notice with respect to the rest of their compensation. So it's really key, and this is my final takeaway, that you have an employment law specialist review your company's equity plan and equity agreements, along with having corporate lawyers do that task. We do our best to try to make sure that we are aligned with our corporate team nationally on these issues. But oftentimes these equity plans come from U.S. counsel, U.S. law firms who don't know the law in Canada, and they don't recognize that there may be employment law issues inherent in their equity documents. And I would say in that regard, you either want to create Canada-specific plans or agreements, or you want to create a Canadian sub-plan. But it's very important to keep the employment lawyers involved. And that's it from my point of view.
Okay, well, that's great, Catherine. We have a few questions, and we'll deal with a handful before 12:30 Eastern Time. The first question is from someone who's already had their employment agreement templates reviewed, but wanted to know whether to connect again to make sure that the Baker and Wigdor cases are covered. And so my answer to that is yes, you do want to, given that these are two very important decisions. I do think it's worth connecting with your legal advisor to have the templates reviewed. Maybe they're fine. Hopefully they're fine, but they might even be further improved with some of the language that we can take from those two Court of Appeal decisions. So it could make your templates even better, as well as if there's an RSU plan, making sure that you follow what Catherine just mentioned with respect to having the employment standards language in that RSU plan. The second question for you, Catherine, is whether Wigdor could end up applying to things such as profit sharing or RSP matching programs.
Yeah, that's a great question. And you don't even have to look at Wigdor to answer that. Profit share, and again, I'm going to speak to this now from an Ontario perspective, but I believe that the law is substantially similar in all common law provinces in Canada. So that means all provinces other than Quebec. We don't purport, Matt or I, to practice Quebec law. And so you'd need to reach out to one of our Quebec colleagues for that. But in terms of profit sharing, in fact, the Ontario Ministry of Labour has specifically confirmed that profit sharing falls under the definition of wages. And RSP matching, likewise, the Ministry of Labour has confirmed that RSP matching forms part of the terms and conditions of employment. So you don't even have to look at the new Wigdor decision. That's a simple matter of interpretation of the ESA, and the ESA requires those two things to continue during at least the statutory notice period. Whether you continue them longer through the common law notice period will depend on how you've dealt with them in your plan documents. If you haven't dealt with them in your plan documents at all or improperly and your employees are entitled to common law notice, then you're going to have to continue profit sharing and RRSP matching through to the end of that longer common law notice period.
Okay, great. And one last question, Catherine, is we've got one person on the webinar who's has their Canadian employees have already signed the U.S. equity documents. They've been issued and they've already been signed. The question is, what do we do now with the Wigdor decision?
Yeah, I think that you want to reach out to your Canadian corporate counsel about a potential the potential creation of a Canadian style sub-plan. Because you probably don't want to be recreating the entire U.S. Plan, and your U.S. Corporate folks won't like that at all. So you want to create a sub-plan, and then you want to get employment counsel involved with that. There may be some questions in terms of the sign-off on that, whether or not potentially a small signing bonus might be required just to ensure that it's enforceable. But it's an easy enough fix. You just need to undertake the work.
Okay, great. Well, thank you very much, everyone, for attending today's webinar. There's a lot of information that we talked about today. We do have our blog and our legal update email list that you can subscribe to. Thank you very much for attending today and have a great day.